Good afternoon, everyone. Thank you so much for joining us today for our focus workshop. We are honored to introduce our good friend, DJ. He has been a longtime family of Focus, and we love supporting him, as well as he supports lots of families that are always interested in Katie Beckett appeals, as well as Special Needs Trust. So please welcome DJ.
All right, thanks so much. Thanks for joining me today. I know it's hard to take your Saturday to spend some time on the computer, but I hope we're going to give you some good information today. There's going to be two different things I talk about today. Both I think are particularly important during the pandemic that we're having now. One is, of course, Katie Beckett. I know a lot of you are enrolled in the program or applying for the program. Many of you have been denied on either initial or subsequent reapplications. What I'm going to talk about today about Katie Beckett is what to expect in an appeal and some strategies on how you can win your appeal. We'll talk about the process, how to make sure that your rights are protected, and I will work my way through that. What I won't talk about is how to apply. There's some other folks that Focus works with who are consultants who can do it in a much more cost-effective way than I can. So I'm really going to talk about once you're denied, how to appeal it, what to expect, and how you can win. The second part of my presentation is going to be about special needs estate planning. Now that part is particularly important these days with everything that's going on in the country and with the virus. We want to be prepared. I think every special needs parent's worst nightmare is who's going to do all the things for our family, for our kids that we do. And it's a very hard thing to face. It's a hard thing to answer. But I want to talk through some of just the high points. It's not going to be a comprehensive presentation, but I'll talk through the high points of really what you need to have in place to make sure your kids are protected. So let's go ahead and get started with Katie Beckett. Okay. What do you do when you've been denied? This is why I've gotten into this space. This is my son, Kai. Kai is 10 years old. He is on the autism spectrum. He's also got a condition called Williams syndrome. He has pretty significant challenges, both intellectually, feeding challenges, coordination, sleeping. We kind of run the gamut, communication issues. He gets PT, OT, ABA. We're on the Katie Beckett program ourselves. We have been denied ourselves. So the reason I present this to you is I approach all these things, both the Katie Beckett appeals, as well as the estate planning from a parent standpoint, as well as that as of an attorney. But this is really kind of why I've gotten into it. Helping special needs families is a passion for me. Okay, so Katie Beckett appeals. What do you do when you've been denied? Well, what do you get in the mail? So you've submitted your application, and the first thing you're going to get is what's called an initial denial. It will say either on the top, initial denial or technical denial. Both of those things are first level denials. Now, the appeal from that is called a request for administrative review. Now, all that means is it's a paper review by the department where you submit additional documentation to prove what the department is saying is incorrect. The reason they're saying, look, we haven't denied you yet, but this is why we're probably going to deny you. You have a deadline in which you want to submit additional information back to the department for them to look at. One of the questions I get at this stage, well, really two big questions. One is, how much should you send them? And I'm on a lot of the Facebook groups where we talk about Katie Beckett denials. A lot of good information out there, and candidly, some not so good information. For your application, if you want to throw in the kitchen sink, that's fine. No issues with that. On appeal, don't throw in the kitchen sink on appeal. Read the paperwork. and try and figure out exactly why you're being denied. You have to remember the department's reviewers don't want to see your application resubmitted, a 300-page application with 5 new pages. Just send them the 5 new pages. Okay. The department's folks, they've got a lot of work to do. They may not spend as much time on each appeal reviewing it. So what I tell my clients is, spoon feed it to them. If it's something as simple as you're not getting your 5 sessions a week of medical or therapeutic interventions, and you're like, yeah, we are. Well, give them a spreadsheet. Say, look, here it is. We're getting PT, OT, speech each week. Here's our schedule. That's 5 times a week. The easier you can make it for the department to identify where in your documents it refutes what they're saying, the easier it's going to be for you to get approved at this stage. Now, the second question I get is, at this initial denial stage, do you need a lawyer to help you? Now, it's a hard question. I can definitely help clients more at the initial denial stage, because I can look at the denial and basically tell the clients what they need to do. This is the letter you need to write. These are the additional documents you need to submit. This is what you need to say in your appeal letter and how you need to structure it. An hour or 2 of my time. Now, contrast that with the next stage of appeal. So you file your initial denial. You get an initial denial, you file your request for administrative review, and you get another denial. Okay, that denial is called the final denial. Now, the appeal from there is a request for hearing. It's really a request for administrative hearing. A request for administrative hearing is court. It's an administrative court, but there's a judge in a robe. The rules of evidence are followed. You have to do openings and directs and cross-examinations. It's court. So if a client has not engaged me until this level, we're now in court and the department has an attorney, and the time it would take me to help the client would be more than if they had engaged me to solve their problem at the initial denial stage. So it's really, it's up to you. If the initial denial is something simple enough, you think that, legal help will not assist you in getting approved, that's fine. But without a doubt, I can help people better at the initial denial and more inexpensively at the initial denial stage than the final denial stage. So those are the two steps. Now, the hearing request goes to the Office of State Administrative Hearings. That is an independent agency separate from the Medicaid department. Okay, and they really have no problem ruling against the department where it's appropriate. So I always get the question, are we going to get a fair shake at this hearing? The answer is absolutely yes, you will. You'll get a fair shake. Do you need an attorney for the hearing? You don't have to have one, but the department has one, and I do think your chances of winning go up if you have one. For either stage of appeal, whether administrative review or request for administrative hearing, make sure you meet all of your deadlines. In the letter you get, the denial letter itself, it will say, from this date, you have X number of days to file your appeal. It's very important to read that carefully, because the initial denial letter, what it generally says, and I've seen it differ between letters, but what it generally says is you have 30 days from the date of the denial letter. Now, it's the date on the denial letter. Clients will call me and say, look, it says October 1st, but we only got it on October 15th. Well, then you got to get it in by October 30th. It's not from the date you get it. It's the date that's on the letter. You have to meet that deadline. Contrast that with the request or the final denial where you request an administrative hearing. That is 30 days from your receipt of the final denial letter. So it's very important to read the letter carefully and know where your deadlines are. You have to meet your deadline. If you don't meet your deadline, what will happen is the department will automatically say, you've missed your deadline. This appeal is now over. And you have to start the process over again. When you mail any of these requests for administrative review or requests for hearing to the address that's in the letter, normally back to the department, make sure you send it certified mail or some way in which you can track the delivery so you have some proof of when it was received by the department. The department gets a lot of mail, and we've heard several times over the years where clients will say, well, we sent it, and the department saying, we didn't get it. I'm sure all of you've heard stories from friends or on Facebook groups about this. Well, if you can't prove that you sent it and it was received, the department's going to just say, we don't have it, you're out of luck. So please make sure to send any documents to the department, whether it's an application, a reapplication, request for administrative review, request for hearing. Always send it in a way that can be tracked. It's very important. So let's move on to the actual administrative hearing, because like I said, the level, which is the request for administrative review, is just you submitting additional documentations to the department. The administrative hearing is where it really kind of gets a little more complicated. Here's something that's really important. The burden of proof at these hearings, just like in any court, it differs depending on whether you've been denied on an initial application or on a renewal application. The reason this is important, we get a lot of clients who say, look, we talked to the department's Katie Beckett review unit on why we're being denied. And what they told us is just go ahead and reapply. Now, if it's an initial application, well, that's one thing. The burden of proof is on you as the family, as the applicant, on that denial. Or if you reapply and get denied, well, the burden of proof is still on you. So the burden doesn't shift there at all. If you have a renewal application that's been denied, and the department says to you, well, you don't qualify now, but if you reapply, you probably will. And you reapply. Well, that reapplication is seen by the department as an initial application. So while in the denial of a renewal, the burden's on the department. They have to prove why you don't qualify on a reapplication. On an initial application, you have to prove why you do qualify. And it really is kind of an important distinction. So before you just listen to the department or to well-meaning folks on Facebook, please, think about the burden of proof and whether you have an initial application or a reapplication. Another reason that distinction matters. Your initial application, if you get approved on your application, if you get approved on appeal, well, your approval date relates back to that date of application. So, for example, you apply on January 1st, but we only win your case on March 1st. Well, you go back to January 1st, and then 3 months back from there. Okay, that's that look back period where you can still get services approved. So that's a big deal if during that period you've incurred some costs that the Katie Beckett program would have covered. If you don't appeal and instead choose to reapply, and you reapply. Well, that time period from March to January, that's gone. That's not going to get covered anymore. You reapplied in March, and so if you get approved, that's great, but it's only from March 3 months back rather than from January for 3 months back. So there's a lot of strategic thinking that kind of goes along with deciding whether to reapply or appeal a decision. So there's some nuances there that you want to consider before you make any decisions. Okay, so on to what to expect at the administrative hearing. Now, like I said before, it's in front of a judge. The department will always have an attorney. They will always have a nurse reviewer who looked at your file testifying. They'll probably also have a policy person testifying. It's generally 2 witnesses and the department's attorney. It's in front of a judge from an independent agency. They'll be in a robe. It'll be in a courtroom. It's more formal. It's not like a mediation where you all sit around a conference table. It's not like that. It's in a courtroom. The rules of evidence do apply. And so if you're not an attorney, the judge does have some discretion on loosening those rules, but they cannot dispose of them altogether. So if you are going to represent yourself in these hearings, just make sure you kind of do some homework or maybe even talk to an attorney who might be able to give you some general advice on evidentiary issues. And just be prepared, be prepared, because what you don't want to have happen is you have all this great information and you go into the hearing and you say, Judge, here, look at this. And the department's attorney objects to it as hearsay or inadmissible for another reason. And the judge says, look, I'm sorry, I can't look at it, right? I mean, there's nothing more deflating to a family than that. So make sure you do your homework. So the way these hearings normally work, both parties go in. The party with the burden of proof goes first. They'll make an opening statement. Then the other party will make an opening statement. For you, the most important thing about this opening statement is to humanize your child. Because right now, all the department has seen is a file and documents. That's it. They've never met your child. The judge has never met your child. They don't know who they are. They don't know what they look like. They don't know if they're a happy kid. They don't know if they're verbal or nonverbal. All they have is a file. Humanize your child. Bring a picture. Bring a video. Bring your child. Now, something that's really important. Do not present the best picture of your child. Do not present the best video, having the best day running around like any other typical kid would. Not that you don't want to misrepresent your child's condition, but give the court, give the judge a realistic view of who your child is. What do they like to do? Who are they? Tell them. That's what the opening statement is for. Opening statement is not evidence. So you can always give some background information. These are the struggles my child has. This is what's been happening. Tell the story of your child and why you need these benefits. You also want to mention kind of your legal case. Why do you meet the criteria? And we're going to go into the criteria in just a little bit. So after the opening statements are done, the party with the burden of proof will call its witnesses. You call your witness, swear them in, and you ask them questions, non-leading questions. Who, what, when, where, why, how. Okay. You ask the questions. You ask as it relates to your child's condition and how that condition relates to the criteria that has to be met to get your child on the program. Okay. Now, after you ask your witness questions, or they ask their witness, whoever's gone first, the other party gets a chance to cross-examine that witness. And I know you've all probably seen Law and Order or lots of other TV shows. Cross-examination is not quite that aggressive, but you do get to ask leading questions. It doesn't have to be who, what, when, where, why, how. It can be, isn't it true? Or don't you? Or say it as a statement, but with a question mark at the end. You don't really look at these, you don't really spend more than 20 minutes looking at these applications. Isn't that true? You know, yes or no answers. After cross and direct are done of the party with the burden of proof, the other party presents their witnesses, and the roles switch. That party directs their witnesses, and the other party cross-examines them. When all that is done, the evidence is done, and both parties make a closing statement. What you want your closing statement to be is, Judge, based on the evidence that's been presented, we meet the criteria because. And you go through, this is what my witness said, this is what their witness said, here's the criteria, and you just kind of match up the facts to the criteria. Okay, and I'll give you examples in just a little bit. You always want to end your closing statement with an emotional plea. We really need this because. This is how this is going to make a difference in my child's life. Without it, this is what's going to happen. One of the things I didn't say at the beginning when introducing myself is I was an administrative law judge, the judge who presides over these cases. I did this job for 5 years. I'm also a judge right now in Gwinnett County, and no judge is immune to the emotional plea. They're not. They may not look it, but they're not. They're parents, they get it, okay? We have, as parents, we have the emotional plea. The department does not. So we need to take advantage of that, okay? And, you know, again, I'm not trying, you know, don't go into hysterics over it, but, you know, look, we need this for our kids because we want them to have the best life and the best chance possible. The judges understand that, and they listen. So always end on an emotional note. It tends to stick with the judges. Okay, so what do you actually talk about at the hearing? Well, almost all of the denials that go to hearing are based on a denial of the level of care, okay? You have to qualify for Katie Beckett by meeting a certain level of care. There were 3, there are really 2 now. One is the nursing facility level of care, which is right here. The ICFID level of care, which stands for Intermediate Care Facility for Intellectual Disabilities, and then a hospital level of care. I have never seen a hospital level of care doing this work for 23 years, so I'm not going to spend any time on that. I will spend time on the other 2. Now, really, you get a lot of kids who might fall into both buckets, and so we get this a lot where either your pediatricians or you will have a question, well, which one do we apply under? Well, the answer is both. Apply under both. Because what the department says they do is that they look at it under both. So check both boxes, you know, make them say no. If the burden of proof is on you, you go through the level of care, and I'm going to show you the level of care in just a moment, but you go line by line. We meet this because. We meet this because. We meet this because. And you have to prove it because the burden of proof is on you. If the burden of proof is on the department, keep track of them going through each line. Okay? They have to go through each line and say, you don't meet this because. You don't meet this because. And if they miss anything in there, well, they haven't carried their burden. So you really have to listen to what they say, what their witnesses say, have the criteria in front of you, and take a red pen and check it off. Yep, they presented evidence on this. They presented evidence on 1, 2, and 3. but they didn't present it on 4. Well, you don't have to say a word about 4 because they failed to carry their burden. You only have to talk about 1, 2, and 3. And again, this is only if the burden's on them. Okay, so let's kind of get to the meat of this. What do you have to prove? Now, this is something. This is I'm giving you my big secret on how to win these cases. This is the ICFID level of care as it looks several years ago. Okay. I know it's hard to read. This is kind of the best I could do. It's available online. But if you look at this, it's very clear what you have to show. Services have been ordered by a physician. Okay, do you have a prescription? And furnished by someone qualified. And would normally be in an ICFID. And then on a continuous basis require treatment, essentially. This is where, if you look at B down here, right in the middle, this is that 5 days a week. Okay, this is where you hear a ton of discussion about this on the Facebook groups and the discussion boards. This is where that comes from, 5 days a week. Okay, notice that says interventions. A lot of people on the Facebook pages get this wrong. They say you need therapy 5 days a week, and that is not what it is. It's interventions. Is it medical? Is it psychiatric? Is it psychological? Is it vision? Is it, weekly trips to the GI? Is it aquatic issues? I mean, it's got to be an intervention, which is much broader than just therapy. And if you look over here in kind of the last column, an individual has to have an intellectual disability or something like it, or a condition that's closely related to an intellectual disability. So this has all the criteria. Now, notice I said this was what it looked like before. This is what it looks like now. A lot less detail. But here's the really interesting thing. So let's just look at the criteria, which starts down here. They've added something which can help us. Has an IQ of 70 or below. That's it. Remember, this says if any of the following conditions are met. So if your IQ is a child under 70, they meet it. Does not matter if they're getting 5 days a week, right? The next one, child has a score of 70 or below in 3 out of 5 domains of functioning on a standardized developmental assessment tool, or an overall score of 70. The next one, score of 70, 3 domains, or composite score of 70 in an adaptive functioning. So not a standardized development, but an adaptive functioning assessment tool. An autism rating above 37, or a Galium autism rating of 121. Now, this is it. You can tell there's a lot less detail, but it's also a lot more concrete. It's just numbers. You can meet them. So here's where you kind of have to be strategic in what you argue. Under ICFID, if you meet any of these 1 through 4, this is the criteria you show to the judge. You show to the department. Look, we have an IQ test that shows below 70. We have standardized tests that show these things, or we have an autism test that shows these things. Easy, easier case to win. If you don't meet these, go back to the previous one and say, look, judge, we meet these criteria. Now, you're probably asking yourself, and the judge is probably going to be thinking, but that's the old stuff, isn't it? Well, yes, it is, but look up here. Okay, this criteria is based on the federal regulations, and it cites the regulations. These regulations have not changed in 20 years. These are the regulations are exactly the same when this was created, the before, as was the after. And so the department was saying, look, if you meet this, you meet ICFID level of care. You meet it. or if you meet this, you meet ICFID level of care. You can argue both, and of course, if you are under this criteria, your argument to the judge is the law hasn't changed, the regulations haven't changed. All that's changed is the way in which the department presents it to us. But the law and the regulations are the same, and the interpretations have to be the same. So I think that's an argument that resounds strongly with the judges. One of the big questions I get with this is, okay, in our initial application or on appeal, we have these tests that show either autism or adaptive functioning or developmental assessments from a school or IEP document. I caution parents, before you submit that with your application or on appeal, really look at it carefully and make sure it meets this. Because if it doesn't meet it, the department will use that against you on any subsequent appeal. Okay, if it shows an IQ of 80, but you come up with something later that shows 70, well, they're going to use your earlier document against you in any appeal. So when schools are doing IEP assessments and they do these tests, they're looking at something different than psychologists or psychiatrists are looking for when conducting these tests for different purposes. You know, depending on what school you're going to, these tests sometimes determine the services your child will get through their IEP, which is a cost to the system. We just don't really know what's going on there. What I would suggest you do is go to a psychiatrist or psychologist and tell them, you going to use this psych eval to apply for the Katie Beckett waiver. Go to a psychologist or psychiatrist who is familiar with the waiver and the criteria that needs to be met. Okay, and they will do this testing with that in mind. They will know that they have to look at these things and what scores need to be met for you to qualify. I think it's important. Don't just throw in an IEP psych eval. All right, I know this one's even harder to look at, but the same thing. This is the nursing facility level of care. Now here again, it is the person's condition is so complex they need supervision or technical personnel to help provide services, and you've got to meet one of these. Well, I know it's real hard to read, but if you can look at it, this is very specific. Okay, intravenous or intramuscular injections or intravenous feeding. Enteral feeding that compromises 26% of daily caloric intake, or provides at least 501 milliliters per day. Well, this is all very, very, very specific. Notice this one is 7 days a week. In number 2 up here, it's 5 days a week. Very, very specific on whether you're going to meet it. Now, let's see what it looks like now. So again, same thing. The federal regulations are cited. So in my mind, that means you can argue either this one or this one, whichever is stronger for you. Okay, because the federal regs have not changed in all that time. Now, look at the criteria here. Ordered by a physician. Well, that's easy. Furnished either directly or under the direct supervision of appropriately licensed personnel. Okay, well, directly is pretty easy. Under the direct supervision of is not as simple as you would think. What does that mean? Does that mean the person's got to be in the room? Does that mean the person can be available by phone? Does that mean that they just review your documentation later? It's not clear. Inherently complex, we have that. And then down here, I'm sorry, inherently complex, we have that here and in the previous criteria. The individual requires either skilled nursing 7 days a week or skilled rehab services at least 5 days per week. Okay. Well, skilled rehab services, what is that? PT, OT, speech, that kind of thing. So there's a lot of overlap with the ICFID. So, argue both. If you fit under anything, that's what you want to argue. But notice things like the enteral feeding. I have a client right now who I'm assisting in the Katie Beckett appeal, where this is what they were given by the department. Say, you don't qualify. Well, as I spoke with the family, it became very, very clear that this enteral feeding option is met, absolutely met. But how's a family supposed to figure that out from this? Well, they can't unless you look at the federal regs, and that's hard. There's a lot of theories on why the department switched to a less detailed option. Some people feel it makes it harder for the average family to figure out what all this means and to argue it at a hearing. That's why I always like to make sure families know about the older versions that are still based on the current CFRs. Look for which one you will meet, and that's what you want to argue. These are the criteria where you want to work your way down the list, or make sure the department works their way down the list, depending on who the burden is on. All right, what happens at the hearing? You can always represent your child at the hearing. You don't need a lawyer. That's federal law. If the department is on the stand, ask them questions about your child. What does your child look like? Have they ever met your child? How long do they spend reviewing each application? Ask them why, who, what, how, a lot. Same for your witnesses. Like I said before, at the hearing, the department will call a program specialist and a nurse. You may want to make sure you get a medical witness to testify for you, either a doctor or a nurse, to the extent that they're needed to talk about a medical issue. It's always better, I think, if you have at least one medical witness to refute their medical witnesses. And remember, one of the strong things about this is your medical witness has treated your child. They know them. They've seen them. They've examined them. They've prescribed for them. The department's nurse reviewer has not. Case law will give you and your caregiver, your medical witness, deference because of your knowledge of the child. One of the things that I always encourage people to ask the department on cross-examination is, how many applications do you review every day? How long do you spend on each application? I know for a fact, because I've asked this question on my hearings, in reviewing that big, thick application you put in, they spend 15 minutes per application. 15 minutes. There's no way they look at every document in 15 minutes, but you have. So your knowledge of the application is going to be better than theirs. One of your other strengths will be the knowledge of the facts. You know your child. What do the records not say? The department's total information is based on the records. What's in between the lines? What do the records not present in terms of the challenges that your child faces? Well, tell the judge that. Make sure they know. Has anything changed since your application? Has there been emergency room visits, surgeries, increased therapies? Make sure the judge knows about all of that. You don't have to worry about subpoenas really anymore. The department should give you, before any hearing, they should give you their entire file that they're relying on to deny your application. If they don't, ask for a pre-hearing conference with the judge. The judge will get on with you and the other side. You can say, Judge, I was supposed to get a copy of their file and I haven't. The judge will order that to happen and give you time to look at it. Okay. I already talked about how to request the hearing. Make sure you track it. If you are being denied on a renewal, Get this question a lot. Can you keep your benefits during the appeals process? The answer is yes, you can. Federal law requires your benefits stay in place if you request them to stay in place in a timely manner. And all of that's in the denial letter. I do want to warn you, though, what the federal law also says is if you do lose your appeal, you can technically be required to pay for those services received during the appeal period back to the department. I've never seen it happen. That's not to say that it can't. The law allows for it. I just have never seen it happen. So that's really it. I know I've thrown a lot at you. I would encourage you, if you get denied, look at the criteria. If you think you meet it, appeal it. Don't get lost. Don't doubt yourself. Don't say, well, the department must know more than I do. The appeal costs the amount of a stamp to mail it in. Appeal it. You'd be surprised. Sometimes the department will just overturn itself. Sometimes they'll admit they're wrong. They won't admit it, but they'll overturn it, seemingly admitting they're wrong. Sometimes they'll overturn it because they don't have the staff to go to the hearing. Appeal it. If you appeal it, you don't have to go to the hearing. You can just try and convince the department, talking to their attorney, here's more information, I think we meet it. If ultimately you've appealed it and you decide, look, I don't want to go in front of that judge, let's just reapply later, or I don't want to fight this fight, you can withdraw the request for hearing. Okay, there's no requirement you go through with it. You just send a note to the judge, and that is it. So I know I've thrown a lot at you. My information will be available at the end of the presentation. Always email me with your questions. I don't charge anything for talking to families. I really want to help you guys with this. And 5, 10, 15-minute conversation is absolutely fine. So let's move on to kind of my second topic, which I think is really important right now, and special needs estate planning. This is the 1,000-foot level. I'm not going to talk about, I only have about 15 more minutes. I'm not going to talk about every document you need, but I will talk about the most important ones. Special needs trust. Okay, we all have heard about it. Some of us know what they are, some of us have them. Some of us who have them don't know how they work. So I want to go through all of that real fast. So first, what is a trust? A trust is a legal entity that is created to hold assets. It can hold bank accounts, it can hold homes, it can hold ownership in businesses, it can hold just about anything. What makes a special needs trust special? Anything in that special needs trust, the government ignores in determining your child's eligibility for SSI or Medicaid, and that includes Katie Beckett Medicaid. Okay, there is no cap on it. Okay, you can have unlimited amounts of money on there, in that special needs trust, and get your SSI and Medicaid. There are some strings attached, which I'll talk about in a minute. But that's how you go about protecting your current and future government benefits. Okay, you contemplate a special needs trust for your special needs child in some manner. One of the things I get a lot, you notice I haven't mentioned a will. Everybody, you absolutely need a will. Absolutely need a will. Let me disabuse you of one notion, and a lot of people get this wrong. I hear this a lot. Well, there's mom and dad, or two spouses, and they think, well, we don't have a will in place, but if one of us dies, everything's going to go to the surviving spouse, and they can deal with a special needs trust or whatever they're going to plan for the kids. That is not the case. That is not what Georgia law says. If you die without a will, your children get part of your estate. Your spouse gets part of your estate. Now, in a typical child situation, not a problem, okay? Because your typical kids, the surviving spouse will control that money as a conservator, not a problem. For your special needs child who has Katie Beckett or SSI, well, that is a problem, because even though part of those assets go to your special needs child and it's still controlled by the surviving spouse, SSI and Medicaid look at a conservatorship as the child's asset, not the parent's asset. So what happens? One parent passes away without a will, part of the money goes to the child, part goes to the spouse. SSI and Medicaid say, whoa, kid's got money now. We're terminating your benefits. Okay, so it's important to put a will in place now, at least if you don't contemplate a special needs trust, at least leave it, say I'm leaving everything to my surviving spouse. That will buy you some time. It doesn't help you if in a situation where both spouses die at the same time, but if one of you passes, it will buy the surviving spouse some time to look at trusts and special needs trusts. So just want to make sure everybody understands that. Okay. Very briefly, there are two kinds of special needs trusts, first person and third. I'm not going to go into the difference that much. The very basics of it are, first person means it comes from your child's asset, the person with the disability's assets. They owned it, and now we're taking it out of their name and putting it into a first person special needs trust to allow them to qualify for SSI or Medicaid. Okay. What's a third person special needs trust? Assets that are funded from any other source other than the person with a disability. Now, why is that important? Because a first person special needs trust has Medicaid payback. What that means is Medicaid is saying, look, you disabled person, you owned that money. Okay, you owned that asset, and we allowed you to take it out of your name and put it in this trust so you can qualify for SSI and Medicaid. But to the extent that we paid for any services for you during your lifetime, after you pass away, whatever's left in that trust, we can take it to the extent that we've paid that amount. All right. There is no Medicaid payback for a third person special needs trust. So if you plan ahead, before money ends up in your child's name, if you plan ahead, you will have a third person trust. And that's what you want. A first person trust really is if you have not planned ahead and we're trying to recover, or there's some legal entitlement like an accident or some kind of legal settlement that has to be owned by your child, that would go into a first person trust, or child support will go into a first person trust. But if at all possible, we want a third person trust for no Medicaid payback. And then when that beneficiary passes away, you as the creator of the trust have determined where whatever's left goes to other children or grandkids or charities. You can make those decisions. It does not go back to Medicaid. Big picture, when and how are special needs trusts created? Two ways. One is called a testamentary trust. All that means is it's created in your will. The blueprint and the guidelines of the trust are in your will. It's a separate section. And when you have passed away, your executor looks at the will and says, okay, there's the trust, there is the trustee who's named, who will run the trust. Call the trustee, here are the funds, here are the rules of the trust, go to work, okay? All the rules and the creation of the trust is in your will, and it springs to life during the probate process of your will. Or you can create the trust right now. We call that the standalone trust. So you don't want a future trust that's created in the probate. You want your special needs trust created right now. Well, we can do that. We draft your trust as a separate document outside of your will, and it's ready to fund right now. You can use it, or a grandparent can use it, or a cousin can use it. Other funding sources can be used because that trust bucket has been created and is ready to receive assets. You cannot use a testamentary trust to take assets before you pass away. You have to have passed away first. Those are the pros and cons to both. And really, it's kind of a fact-specific inquiry on what's right for you. Glad to talk to you all about it and help you decide which one's the best. Those of you who have special needs trusts, what can you use it for? Big picture, I'm not going to go into everything. Big picture is you cannot use it for food or shelter without affecting your SSI benefits in some capacity, okay? You can use it for anything else. Now, there are lots of strategies where you can use it for food and shelter. It will affect your SSI a little bit. You can use your trust to hold things like the home. There are lots of strategies to not get around, but to work with that prohibition of food and shelter. Make sure that you talk to your attorney or your financial planner or your CPA about it. Okay. In your will, you're going to choose your guardian. What's really important about the guardian? Ask a million questions if you have a special needs child. Ask a million questions about the guardian. Do they have the energy? How is their health? How many kids do they have? Are their spouses on board? Are their kids on board? Do they have the patience? Where do they live? I get a lot of people appointing guardians who are out of state. Well, that may be fine, but consider not only has your child lost their parents, but now you're taking them from their home and their school and their friends and their surroundings, and you're moving them. So not only have they lost their parents, but they've lost that as well. Now, it still may be worth it to move them because the guardians in this other state are so great, but you've got to weigh that against, do we have a good choice for guardians here, or we may be able to leave our kids in their situation? Okay, running out of time, so I'm just going to kind of go through this real quick so I can get at least some questions in here. Guardians are over the kids, trustees are over the money in the trust. We do advise people, do not make your guardians and trustee the same people if you can avoid it. They tend to act as a nice check and balance against each other or with each other. They should work together for your child's benefit. But you know, it always pays in a special needs trust, which may last the lifetime of our child, a long time. It pays to be a little bit paranoid and have more sets of eyes on the child and the child's money to make sure everything's being handled like it should be. Prepare your guardian for success. Tell them about your child now, obviously, while you're around. What makes your child happy? Are there bedtime processes? Tips on taking meds? If your child has communication issues like mine does, you have to, you have to teach your guardian how to communicate with your child. The example I always give is the swimming goody. My son, in context, one day my wife and I won't come home. And the guardian comes home, my child will think mom and dad aren't home, it's dark out, they should be home. He'll start saying swimming goody, swimming goody, swimming goody. Well, if the guardian doesn't know what swimming goody means, my child's going to get more anxious and start melting down, and this really bad situation has just gotten worse. Well, swimming goody, just if you need to know, swimming goody is a particular episode of the Mickey Mouse Club about a swimming goldfish. My son calls it swimming goody. You have to tell your guardian these things. It takes a second. Write it down, record it on your iPhone, send them the video of your bedtime process, whatever it is. Send it to them now so they can ask you questions. And God forbid, if they have to step into your shoes, they're ready. Okay. ABLE Act. ABLE accounts are great. They do not replace a special needs trust. There are great tax benefits. that you have in an ABLE account that you don't have in a special needs trust. ABLE accounts are capped at $15,000 a year deposited into that account. So that's a big difference. The tax benefit's a big difference. And the other thing is when the beneficiary of the ABLE account, the person with the special needs, when they pass, to the extent Medicaid is paid for anything for your child, from the date the account was open to the date they pass, Medicaid can take it. Okay, that's another difference. So bottom line is really you want both. You just want to make sure you and your trustees understand the pros and cons and how the trust is different from the ABLE Act. All right, that is it. My email address is down here on the bottom. It's dj@jeylaw.com. Email is the best way to get me these days. This is my phone number, 678-325-3872. Just as a warning, especially with the Katie Beckett, this information is current as of today. I cannot guarantee it's going to be valid, a month from now, 2 months, 3 months. So always check with an attorney. You're always welcome to check with me, and I'll be glad to help you as best I can. So I wanted to see if there were any questions. So let me close that and see Q&A. Okay. So how do I receive proof that Katie Beckett received my application if I drop it off in person at their office? It's a good question. So what I would suggest you do is you take with you just a typewritten page. So it says, proof of receipt on top. Okay. Submitted Katie Beckett application on this date. You fill it out and you take it in there. You have them sign it and take that home with you. Okay. If approved, how often does Katie Beckett have to be renewed, and is the process as extensive? So it has to be renewed every year, but it's not always the same extensive process. They have short forms and long forms. Short forms can last you can do up to 3 years. Then I believe on the third year, you have to do the long form again. Short form is real easy. Long form is really just kind of almost like a reapplication. So it is as extensive when you do the long form. All right, next question. How long does it take to find out if your application has been approved or denied? With COVID, it's been a little longer. Generally, I'm hearing about 2 to 3 months, but it helps to be the squeaky wheel a little bit, stay on top of asking questions. If you haven't heard from them in 3 months, I would start following up with the Katie Beckett office. I've heard it from a number of people these days. A lot of people are working from home, and so the processes have changed. Where they'll wait 4 or 5, 6 months, then they'll start contacting Katie Beckett, and Katie Beckett will say, "What application?" And the client will say, "Look, we have proof it's been delivered." Katie Beckett will say, "Well, can you resubmit it?" And then the process has gotten pushed out. So I would wait 3 months before you start asking. All right. So we applied when our baby was 2 months old and things have drastically changed. We can use the new info in our appeal, or do we have to reapply? You can use the new information in the appeal. The department may argue against it, but in my experience, the judges basically look at, on the date of the appeal, do you qualify on that date? Not did you qualify on the date of application? The judges want to get to the right answer and not have to make the parents jump through hoops again. If they know on that day you're going to, you're just going to come back and be approved. So yes, I think you can use the new information. If the child has a life insurance policy, is this considered an asset of the child? It depends if it depends if the life insurance policy is on the child themselves. It depends who the beneficiary is. Now, if the child is the named beneficiary of the life insurance policy, then no. not until they get the assets from that life insurance. So parent dies and the child's named themselves and they get that money, then yeah, obviously that's their asset. I hope that answered that question. I don't see any other questions. Does anyone have any other questions about anything? I do a lot of now comp work, the estate planning, Katie Beckett. Anything you all want answers to, I'll do my best. So if you have questions, shoot. And if not, we'll give it a couple more minutes. Jade?
Hey, DJ. Yeah, we'll see if anyone has any burning questions. And if not, I really appreciate your time on this beautiful Saturday.
It's my pleasure. Thanks for having me. I don't see any other questions. Last one was at 2:52. I hope you all found this useful. Please do email me if you have any questions at all. There's one last thing real quick, Jade. I've been doing 1-hour consultations on the estate planning free of charge by Zoom for families. We're continuing to do that through the end of this month. As long as you schedule by the end of the month. During that consultation, we walk through the entire estate plan in detail as it applies to your family, but I'll also talk to you about anything you want to talk about. If you want to talk about guardianships, if you want to talk about Katie Beckett, if you want to talk about now comp, if you want to talk about what I do for my family in terms of funding, I'll talk about anything you want to talk about to help you guys. And like I said, it's free through the end of the month. And starting October 1st, we charge $100 for that. But if you hire us to do your estate plan, we apply that $100 to the cost of your plan. But I do encourage people to take advantage of it. You know, it's a free hour, and the worst I'll do is bore the pants off of you. So just email me if you would like to set something up.
Thank you, DJ. Looks like we have one last question.
Okay. Okay, there's. Do I need to change my life insurance policy beneficiary to my child's special needs trust instead of the child's name? Absolutely, yes. If you have created your trust as a separate entity outside of your will, then you name that very specific, whatever you've named your trust is the beneficiary. If you're doing a testamentary special needs trust, meaning it's in your will, technically what you do, there's very specific language, but technically what you're doing is you leave it to the then named trustee of that trust to hold in trust for your child in the testamentary special needs trust. But yes, absolutely, that's one of the things you need to do.
TJ, thank you so much for sharing your knowledge with our families today. We definitely look forward to any other workshops we have where we can always have you.
Thanks, Jade. I appreciate the opportunity. You guys all have a great weekend.
Thanks, DJ. You too.